Hello, everyone. Welcome back to another episode of the Divorce Differently podcast. In today's episode of Divorce Talks with Irwin Mitchell, we're talking about prenups and why they get a whole lot more complicated when you're an international couple. A prenup isn't just a contract, and especially across borders, it can mean different things, hold different weight, and create unexpected consequences if you ever separate. So, in this episode, we're going to unpack what international couples need to know, the common misunderstandings, and especially how to avoid the cross border pitfalls that can catch people by surprise. To talk about this, I've invited Charlotte Clewes. Charlotte is a legal director in the family team at Irwin Mitchell's Birmingham office. With over a decade of experience, she advises clients across all areas of family law, with a particular focus on complex financial matters following the breakdown of relationships. She has specialist expertise in advising on pre- and postnuptial agreements, cohabitation agreements, and disputes involving children. Charlotte, it's so nice to have you today. Thank you for joining me.
Thanks, Chloe. It's lovely to be here.
So maybe to level set, maybe we can start by talking about what a prenup actually is. How formal does it need to be, etc.
Yeah, so I mean, a prenuptial agreement is a contract that's made before marriage. So it sets out about finances and assets, and it handles what happens if a relationship ends. It's not just for the wealthy, I think, to make that very clear. It's not just for wealthy people. It's about clarity and certainty for anybody who wants that sort of insurance policy. You know, people have insurance for cars, travel, health, all sorts of things these days. And I think a prenuptial agreement really should be seen as an insurance policy to cover the position in the event of a later separation. So really, I love that. That's how I like to kind of analogy for it. Yeah, so it's an opportunity to set out intentions, financial objectives, what happens on the event of a separation. You know, anybody can benefit from one. There really can be more relevant in certain circumstances. So I'll just touch on those slightly. So prospective spouses with a significant disparity in their assets and income might want one to cover the position so that they can govern what might happen, so that they feel they'll be leaving in a fairer position. Prospective spouses that anticipate inheritance coming in at some point, if there's a significant inheritance coming in the future, they might want to make provision for that to make sure that it is done in the way that they want it to be and their intentions at this stage. Somebody who might have a significant earning capacity or a business, something like that they want to protect. They can be done by clients' first marriages, second marriages, third marriages, any marriages really. I think a lot of people come for prenuptial agreements when they've had a first marriage that's gone really wrong. And they come, you know, they've been through that horrible process and they think, I'm not doing that again. They come to have a prenuptial agreement to kind of make sure that they can provide what they want to happen on the next marriage. A lot of people do that, and also to protect things for their children on a second marriage. You know, it might be children from a former relationship and that sort of thing. So that can be a situation where they might want to do that. In terms of what we cover in one, you can really cover anything that you want to. You know, it's your agreement between you. You can put what you want in. Often people, as I said, you know, premarital wealth, business interests, inheritance, those sorts of things. But you can cover spousal maintenance, treatment of gifts. I mean, people go very far with the things they put in there. It's essentially up to you what you put in there. There isn't one size that fits everybody. They're there to work for the benefit of the parties, and you know, you put in there what you want to put in there.
So they might want to focus on the specific asset, or there's different conditions they can choose to put in there.
Exactly, yeah. And I think the important thing is, don't leave those decisions to somebody else later. You know, now make sure that while you're in a position to agree something between you amicably, don't leave it to chance later, because you know, on a later separation, the trust is gone. Those things that you think somebody would have agreed to, you know, oh, I don't need one, we'll agree that it'll be fine. It isn't fine, and often that doesn't happen in that way. And you know, with the benefit of hindsight, you can always say we should have done it, but actually I'm telling you, you know, it's a good thing to do to make sure that you look at that. And I think obviously postnups are something that we haven't really touched on yet, but I think just to mention with regard to postnuptial agreements, they're very similar to prenuptial agreements. And I know people would have heard of prenuptial agreements, not so much postnuptial agreements, but I think it's really worth mentioning that as well. You know, they're they differ because they're a contract entered into after marriage, not before marriage. And the difference with that is they're slightly more tricky because you already have claims, you're already married. If you don't do a postnuptial agreement, the claims are there on a divorce. So you go in with a bit of a different mindset. But I think if you haven't done a prenuptial agreement for whatever reason that might be, and it might be that inheritance comes in much later or something happens during your life that means that actually it's more relevant at that time than it was before, a postnuptial agreement is another good way of making sure that you can protect that whilst you're still in a happy place and happy to agree that. Just with regard to postnups, what I would say is some people come to us on the brink of divorce, and a condition of trying to stay together and going to counselling is that they have a postnuptial agreement to set out what might happen on a divorce. And we just have to be really careful with that, because sometimes one party, you know, they might agree to something inadvertently because they want to get back together and they want to, you know, to work on their marriage, and the other party might have absolutely no intention of making things work and they just want them to sign a postnup.
Strategizing.
So, you know, just want to think about, just be really mindful about the kind of thought process behind a postnuptial agreement. Usually it's there for a reason, but making sure that people don't enter into one by accident or, you know, for the wrong reasons, shall I say.
On false pretenses. Yeah.
So
there's a lot of talking. It's something that I hear a lot from my clients around the value of prenups, and you know there's been a lot of progress, I guess, in that direction in the courts lately. But there's still people who are concerned that it's not worth the paper it's on, and others who really think it's going to be the holy grail with regards to their divorce. So what is really the answer with regards to the legal value of those documents?
Yeah, I mean, that comes from the fact that in England and Wales, they're not binding, but they are very persuasive. So since 2010, there was case law that meant that the courts would then follow prenuptial agreements generally, as long as they're done in the right way. So as long as parties have had full financial disclosure, they've had independent legal advice, both of them. So making sure that whichever party it is, if one party can't afford the legal advice, that the other party is paying for that legal advice for them. It's really important they have parity of legal advice. Making sure that it's signed well in advance of the wedding, ideally 28 days, you know, preferably much in advance of that.
The longer the better.
Exactly. Nobody wants to be doing a prenup just before their wedding, and complications come in with that sort of situation as well. And also ensuring that the terms are fair. So, you know, in other countries, and we can come on to this in a bit more detail, but in other countries, there's not so much emphasis put on fairness. But in the UK, in England and Wales, when they come to court to be looked at and tested, they won't just hold you to an agreement if it's not fair and if it doesn't provide for basic needs for somebody. So when we're negotiating these agreements, we need to make sure that we've thought about every situation and every scenario that might arise to make sure that they are fair and they will work. And what I tend to do when I'm drafting prenups is we look at the sort of provision that we might want to make and think about how that might work. And then we just stress test it. So think about different scenarios that could happen that are individual to that person's circumstances over the course of the next 20, 30 years. And obviously you can't crystal ball gaze.
You can't predict everything. But
but have a think about the sorts of things that might happen. So children, you know, where you might move to, what you might do, what the intentions are, and just stress test elements of that so that if something happens, we've made provision and we've covered that. If something else happens, we know that we're covered, because that's the big part where if something happens and it hasn't been thought about at a later stage, that's where the fairness element comes in. So making sure we stress test as well. You can't just put something in there and not give it any thought. And that's why these agreements are really bespoke and they're really individual to everybody's circumstances.
And so I can see how in the context of an international divorce, it gets even more complicated. So, I mean, for example, if you have ties to another country, it would make sense to plan for making sure that prenup would be valid in that country, because a lot of the rules you mentioned are UK specific. They wouldn't be the same in another country. So for people who get married elsewhere, what can they do to make sure that their agreements are protected no matter where they end up physically?
So I think the difficulty is that obviously at the outset, you don't necessarily know where your marriage will take you in the future. But I think the most important thing is if somebody is looking to do one under England and Wales law and they're looking at how that works, I think the starting point really is to look at what the intentions are during the marriage. So where do you intend to live? Where are the assets that you're trying to protect? Where are they based? Because those things will then kind of feed into what the best place is for you to have your prenuptial agreement. Because ultimately, you know, you could do one in the UK, you could do one in England and Wales, but it might be that with the benefit of some cross-border advice, that you're better off having an agreement done in another country with input from us in the UK. So I think the first step is to look at what international aspects are relevant, what countries, get the advice in the different countries as to how they approach them. For example, France is very strict in the France regime. They strictly follow a prenuptial agreement, and that's it. I think many states in America are the same as well. Now, other countries are not the same in that way. So I think it's really important looking at where the assets are, where the links are, where you might live. I mean, sometimes there could be 3 or 4 or 5 or more jurisdictions that are relevant. And I think it's really important to get advice in all of those different countries and just come back and get everybody together and think about where should we have this agreement, and then feed in. So people might have heard of mirror agreements, and that I
was going to ask you about those.
So that is something that can be done. We're tending to move away from those more so, certainly in England and Wales. The reason being is because there have been cases where mirror agreements have complicated and confused things rather than helped things because of the conflict between the different countries. So generally and sometimes a mirror agreement might be the right way. So I'm not saying don't use them at all. As I say, it's bespoke. One size does not fit all. But generally, a better approach could be to consider those aspects that I've talked about, and then think about which country is the best place to start the agreement. What's the main asset? What's the main connection? What's the main risk? And then look at and then go from there and add in bits from other countries. So if we decide that England and Wales is the right place and we're going to do our agreement here, we would then get advice from different countries and input into the drafting to make sure that it will be enforced. It's
valid in those countries too.
That's the difficulty. And each country, not only in terms of their enforcement bits, so there might be things that you need to do to make sure that they can be enforced.
Like disclosure, etc.
Disclosure, there's certain countries have different regimes that you need to make sure certain wording is included in there to make sure that covers it. And I think every country is quite different, and one size is not the same for everything. So doing that, but also even once you've got your agreement, making sure that you've notarized it, you've translated it, you've done whatever you need to do to make sure it's recognized in that country, because those things, those extra steps are also really important.
So you mentioned mirror agreements, which, just for those who don't know, it's literally making another version of the prenup in another jurisdiction and following their rules. But what about dating a prenup? So if you get married in, I don't know, in Germany, but then 20 years later you're moving to Singapore and you're going to be settled there. Can you transfer it over? Do you need to create a new one there as a postnup? How would people go about that?
I think it's always good to take advice in the country that you move, the relevant country, because every country will be different. A lot of prenuptial agreements used to have what I call review clauses in, and review clauses will say, if this happens, if that happens, if the other happens, you should review your agreement and update it. We are trying again to move away from review clauses more so now, and the reason being is because people have these in there, they don't do anything with them, they forget about them, they put them in the drawer, never look at them again, and then 10-20 years later you come to them and then you say, well, actually you didn't review it when this happened, you didn't review it and this happened, and actually then it might not be worth the paper it's written on because you haven't followed through with the things that you intended to do. So I think if you're stress testing and thinking about all those things that you need to do in advance, hopefully you've forecast and thought about any potential scenario so that you don't need to do a review. If you do a review, then it's really fundamental that you actually do review it. So diarising it, make sure you don't miss it. Even if you have a letter that's attached to it to say, we looked at it, we agree it's fine, no review needed, that's fine. But just to show that you've thought about it and you haven't just ignored it is really fundamental, because that's when things can go wrong. In the scenario you mentioned, if in the future you move to a different place, I think checking that hopefully you did the agreement at the time with the knowledge that you might subsequently move to Singapore. Yes, if you did, then hopefully it does what it needs to. But if you haven't thought about it, then fundamentally get that cross-border advice, get the advice in the country that you're moving to. Would this be what we need to do? Is there anything else we need to do? And it might be just an annex, it might be that it works, it might be a post-nup, but don't ever assume that whatever you did 10-20 years ago is enough to cover you, because laws change, all the jurisdictions are different. It's really important. And even if you don't have a review clause, if you have a fundamental event that changes things in the future, you can always look at prenuptial agreements, and you can always review yourself if you choose to, on big events. Hopefully your agreement protects you and you don't need to, but if you want to, that is something that you can do as well.
And is there an option of agreeing up front on a jurisdiction in case of divorce? So could the prenup say, we will divorce in X country, and that becomes, a binding agreement?
Yeah, so you can include a choice of law clause and a jurisdiction clause, but it's not foolproof. And the difficulty with this is, it reduces uncertainty. So it means that, you've got your intentions set out there. And in England and Wales, and obviously that's the law that I can comment on in that respect, they would look at that and they may stay legal proceedings, which essentially means put them on hold if you issue in England and Wales and you've got a jurisdiction clause in another country, a choice of law clause. And if there are proceedings in another country, that could happen. The difficulty is that other countries may not take that same approach. So whilst we may take that approach here, others don't. So it sets out intentions, and certainly it would help and it's worth doing, but you can't again assume that it will just be followed in every country anywhere and that you're absolutely certain. So it reduces risks and those sorts of things. It means there's less chance of an unpredictable outcome. Reduces the chance of one spouse picking the jurisdiction that suits them best. But as I say, there's no absolute ironclad guarantee that that's going to mean that it will be done in that way. And as I say, it's really important that you get advice from the different countries to see, would they look at this? How would they look at it at that time? Is there anything else that we can add in to make sure that in another country they will look at it in that way? Some countries don't recognise and follow certain clauses, so it's just really important to get that local advice in the relevant country at the time. And it's just really important to consider domicile, habitual residence. These are all very technical legal terms, but it's really important to just think about things with a specialist, cross-border advice, all of those things, just really important.
So that kind of clause, it can't hurt. It doesn't sound like it would be harmful to have that kind of clause.
Exactly.
It's not enough to 100% rely on. But I would assume that in the context of a jurisdictional conflict, where each spouse is going for a different country, it would carry some weight in the decision making.
Certainly in England and Wales, a judge would take that into account, that was the intention. Certainly,
Okay. And are there any other pitfalls that you would warn people against in this kind of international context?
In an international context, I think the main thing is just make sure you get cross-border legal advice. Nothing can underestimate the value of that. Other pitfalls are fairly similar in terms of how you approach them. So signing too close to the wedding, that will always be something that has to happen. Don't do it the day before, do it in advance. What I would say is it's still better having some kind of prenuptial agreement, even if it's really close to the wedding. But I would say if you end up doing one really close to the wedding, follow it up with a postnuptial agreement. So if the international elements make it so complex that you think we're just not going to get this done, have some kind of heads of terms almost, so a summary of what you intend and agree, even if it's not a full drafted prenuptial agreement, have something in place, and then follow it up with a very detailed postnuptial agreement, so that you almost sandwiching, you call it, you have your starting bit, you have your filling, your wedding, and then you have the final bit, and you conclude it in a postnuptial agreement. I think with any prenuptial agreement, pressure is really important to make sure that that's not there. And if there's lots of different jurisdictions, there's lots of different countries and lots of complicating factors where you might live, properties elsewhere, pressure can feel really immense. And I think making sure that isn't something that overtakes everything is important. There's always some pressure. I don't think we can take that away. It's an agreement that needs to be negotiated, and hopefully everybody will have input on it, but there will likely be some pressure. So that's not to say there won't be any, but just making sure that it's an acceptable level. And in terms of a practical tip on that, not everybody will approach things in the same way, but some people might be better having a chat together about it at home. Some people might say, actually, this is too much pressure. We're not going to talk about this at home at all. We'll leave it to the legal advisors.
Let the lawyers
we won't do this. But I think whatever, have a chat. If, in those sort of circumstances, if you're feeling a lot of pressure, have a chat with your solicitor and just, see how we can make that better, because there will be ways to reduce that. But the timing element is the biggest one, because if we've got a year, the pressure is reduced because you can just take a bit of time in between,
of course,
have some counselling and that sort of thing, if that will help. I think really a prenup should stand the test of time, and therefore if, as long as you've considered everything really well at the beginning, hopefully you don't, that the pitfalls won't come in, because you'll have already explored all of the international aspects, thought about what you might do in the future. Nothing is foolproof. There's always going to be things that come up, but I think if you've given it plenty of time and thought about it in advance, then hopefully you will have covered everything. I think making sure that you assume that one prenup works everywhere, that it doesn't always.
And don't assume. Absolutely.
Don't ever assume. Listen to advice, take advice, and most importantly, get advice from different countries to make sure that you've done that. It sounds obvious, this one. Financial disclosure is one would think, quite an easy topic. You let each other know what you've got, and you do that. In a prenuptial agreement context, it's not, you don't need to do the level of disclosure that you do on a divorce. So people might have heard in a divorce, you've got to do these really long forms, you've got to include your bank statements and go through everything in a lot of detail. So you don't have to do it to that extent in a prenuptial agreement. You just need to exchange a form of financial disclosure that you're both happy with, so that you're both satisfied with what the other has got, and you have an understanding. This sounds obvious, but there was a case recently whereby one of the parties gave their disclosure, and they said, I've got this much in assets. It happened to be 18 million, but it could be any number of assets. This is what I've got, and they were very specific, that they were very clear that this was their full, frank financial disclosure. I have this much. It later transpired that they had 3 times that amount. And that is obviously a fundamental non-disclosure, and that obviously has an impact on the agreement and its validity afterwards. But I think, and that's a stark example, but I think, if we were talking smaller figures, don't say something is exactly what it is if it's not. And if you're not sure, then you can be clear about that, with a company, without having a full valuation, which you're not likely to want to do at the stage of a prenuptial agreement. It might be an accountant's indicative valuation. Be clear that that's what it is. The accountant has valued this somewhere between X and X, and it could be brackets, and those brackets might be fairly big, but just be really open about it, and don't be too definitive, because it's not necessary on a prenuptial agreement. And actually, by being too definitive, you might tie yourself up in the wrong way later. So just being really clear about that as well.
So I have one last question, because we often think of prenups for money, but can a prenup include clauses around the children or the future children, or maybe even children that they might have before they get married? Can that be included in a prenup?
You can include provision for children, but the problem with that is that the court's jurisdiction can never be ousted. What that means from a perspective is really that you can't contract out of things for children. So if you can put things in, you can put intentions in for children, you can put, housing, school fees provision, you can put all of that in there, and you can think about it, and it's a good thing to think about what the children will need and want, and that sort of thing. But I think everybody needs to be aware that the court retain that power to make orders for children, whatever. So
based on their well-being and what's best for them.
And that goes one step further than, in the context that England and Wales have the power to vary prenups if they're not meeting need. It goes one step further than that. There are separate claims that could be made for children in terms of finances under a separate legal provision. And you need to make sure that you're not kind of going further than that. And I think quite often in a prenuptial agreement, what we will do is be guided by what financial provision might be available for the children in the context of Schedule 1 of the Children Act, which is the law that applies to that. And that might guide what provision we put in the agreement, so that in the event that, it was later looked at, actually, well, the provision under Schedule 1 would be the same as what we've put in the agreement, and therefore it work. Again, stress testing in that scenario as to how that might work with children. And normally prenups don't go into arrangements for children and that sort of thing. You wouldn't normally go that far.
I was going to ask about relocation, actually. You know, when a couple knows, so say you're a couple from the UK, but you're going to be expats moving around all the time, having a provision that says if we were to divorce, you know, one of the parents and the children would return to the UK. Is that something that would have any kind of validity?
No, I mean, obviously, as I say, you can put whatever you like in an agreement, but the reality is at the time that happens, the court will look at what is best for the children, where they are actually living, you know, what ties there are, you know, they'll look at each case on its merit at the time that the children are going. So, you know, by all means, you can include intentions. I don't think that hurts because obviously if you're then both having to do detailed statements in subsequent children proceedings about that issue, you go back to, well, this was the intention and it evidences intention. So as I said, I don't think that hurts at all. But I don't think you can go into that thinking that will be absolutely what happens, because ultimately
it's not a bulletproof clause.
No, the court retains that jurisdiction, and the court will always have the power. The court in whatever country the children are in, you know, at that time will always have the power to make those orders that are appropriate for the children.
Makes sense. Thank you so much, Charlotte. So much useful information. I think what I've taken away is really the need to try and anticipate as much as possible countries that you know you have ties with, and make sure that your prenup is valid in all those different countries and has been considered in that light. But then, of course, life happens and there will be changes. But as you said, there's opportunities to review these agreements, so they don't need to be set in stone. Thank you so much, Charlotte. Thanks for all your tips. Your contact details will be in the episode description. So if people want to reach out to you for help, they can in that context. And have a great day.
Thanks very much, Clary.